The manner in which the covenant was enjoined to be taken in Scotland, quote, under all civil pains, unquote, has not been approved by seceders in any of their public papers. Private writers of their connection who have vindicated the injunction clause have not considered it as extending beyond exclusion from places of power and trust. Whatever may be the legal import of the phrase, I believe this interpretation accords with the fact, and, so far as I know, it cannot be shown that, with the consent and approbation of the public authorities, the covenant was forced upon any, or that the loss of liberty or of goods was incurred by them for simply refusing it. I frankly confess that I have not yet seen any good reason, in point of religion, justice, or good policy, for condemning the exclusion of those who did not take the Solemn League from places of authority and public trust. It was the great bond of union and test of fidelity among those who were embarked in that cause in defense of which the Parliaments had already drawn their swords. A due regard to the high interests which were at stake, as well as their own safety and the maxims of prudence by which all people are guided in similar circumstances, required that they should carefully distinguish between those who were well or ill affected to their cause, and that they should not entrust the more active management and defense of it to such as were of the latter description. In the extraordinary circumstances in which they were placed, a mixed test, partly civil and partly religious, became so far necessary to ascertain common friends and foes. There might be, I have no doubt there were, individuals, peaceably disposed, and even friendly to the cause of the Parliaments, so far as civil liberty was concerned, who yet scrupled at the stipulations in the covenant which related to religion. But laws cannot be made for individuals. It belonged to the public authorities to determine what description of persons it was safe, in the peculiar circumstances, to entrust with power, and in times of national confusion, danger, and war, when all that is valuable to a people may be put in jeopardy, individuals may be required to forego, or may be restricted in the exercise of those rights which, in an ordinary and quiet state of society, they may be entitled to claim. The vindicating of such tests in certain times, and in reference to certain parties, does not imply an approval of them in all times or in reference to parties of a very different description. The continued obligation of our national covenants is of greater importance than any particular measure adopted in prosecuting them, in that I have to say on this branch of the subject. I shall keep the Solemn League more particularly in eye, both because it comprehends the substance of the National Covenant of Scotland, and because it has been the object of more frequent attack. It is not every lawful covenant, nor even every lawful covenant of a public nature, that is of permanent obligation. Some of both kinds, from their very nature or from other circumstances, may undoubtedly be temporary. The permanent obligation of the Solemn League results from the permanency of its nature and design, and of the parties entering into it taken in connection with the public capacity in which it was established. Some talk of it as if it were a mere temporary expedient to which our forefathers had recourse in defending their civil and religious liberties, and, when they have paid a compliment to it in this point of view, they think they have no more concern with the matter. This is a very narrow and mistaken view of the deed. The most momentous transactions, and most deeply and durably affecting the welfare and the duty of nations and of churches, may be traced to the influence of the extraordinary and emergent circumstances of a particular period. The emergency which led to the formation of the covenant is one thing, and the obligation of that covenant is quite another. The former might quickly pass away, while the latter may be permanent and perpetual. Nor is the obligation of the covenant to be determined by the temporary and changeable nature of its subordinate and accessory articles. Whatever may be said of some of the things engaged to it in the Solemn League, there cannot be a doubt that in its great design and leading articles it was not temporary, but permanent. Though the objects immediately contemplated by it, religious reformation and uniformity, had been accomplished, it would still have continued to oblige those who were under its bond to adhere to and maintain these attainments. But, unhappily, there is no need of having recourse to this line of argument. Its grand stipulations remain to this day unfulfilled. The Solemn League was a national covenant and oath in every point of view, in its matter, its form, and authority by which it was enjoined, the capacities in which it was sworn, and the manner in which it was ratified. It was a sacred league between kingdom and kingdom, with respect to their religious as well as their secular interests, and at the same time a covenant in which they jointly swore to God to perform all the articles contained in it. National religion, national safety, liberty, and peace were the great objects which it embraced. It was not a mere agreement or confederation, however solemn, of individuals or private persons, however numerous, entering spontaneously and of their own accord into a common engagement. It was framed and concluded by the representatives of kingdoms in concurrence with those of the Church. It was sworn by them in their public capacity, at their call, and by their authority. It was afterwards sworn by the body of the people in their different ranks and orders. And finally it was ratified and pronounced valid by laws, both civil and ecclesiastical. The public faith was thus plighted by all the organs through which a nation is accustomed to express its mind and will. Nothing was wanting to complete the national tie, and to render it permanent, unless it should be maintained that absolute unanimity is necessary, and that a society cannot contract lawful engagements to God or man, as long as there are individuals who oppose and are dissentient. Sanctions less sacred and pledges less numerous would have given another nation, or even an individual, a perfect right to demand from Britain the fulfillment of any treaty or contract. And shall not God, who was not only a witness but the principal party, and whose honor and interests were immediately concerned in this transaction, have a like claim, or shall we break the covenant and escape? Some of the principles on which it has been attempted to loose this sacred tie are so opposite to the common sentiments of mankind that it is not necessary to refute them, such as that covenants, vows, and oaths cannot superadd any obligation to that which we are previously under by the law of God, and that their obligation on posterity consists merely in the influence of example. There is another objection which is of a more specious kind, and lays claim to greater accuracy, but which on examination will be found both unsolid and inaccurate. It is pleaded that it is only in the character of church members that persons can enter into religious covenants or be bound by them, and that the covenants of this country can be called national on no other ground than because the majority of the inhabitants in their individual character voluntarily entered into them. At present I can only state some general considerations tending to show the fallacy of this view of the subject. By church members may be meant either those who are in actual communion with a particular organized church, or those who stand in a general relation to the Church universal. But in neither of these senses can it be said that religious covenants or bonds are incompetent or non-obligatory in every other character. This is to restrict the authority of the divine law in reference to moral duties, and to limit the obligations which result from it in a way that is not warranted either by Scripture or reason. How can that which is founded on the moral law, and which is moral nature, not positive, be confined to church members, or to Christians in the character of church members only? The doctrine in question is also highly objectionable, as it unduly restricts the religious character of men and the sphere of their action about religious matters, whether viewed as individuals or as formed into societies and communities. They are bound to act for the honor of God, and are capable of contracting sacred obligations, sacred both in their nature and in their objects, in all the characters and capacities which they sustain. I know no good reason for holding that when a company of men or a society act about religion, or engage in religious exercises, they are thereby converted into a church, or act merely and properly as church members. Families are not churches, nor are they constituted properly for a religious purpose. Yet they have a religious character, and are bound to act according to it in honoring and serving God, and are capable of contracting religious obligations. Nations also have a religious character, and may act about the affairs of religion. They may make their profession of Christianity and legally authorize its institutions without being turned into a church. And why may they not also come under an oath and covenant with reference to it, which shall be nationally binding? Covenanting may be said to be by a nation, as brought into a church state, acting in this religious capacity. The oath may be dispensed by ministers of the gospel and accompanied by the usual exercises of religion in the church, and yet it may not be an ecclesiastical deed. The marriage covenant and vow is founded on the original law, and its duties, as well as the relation which it establishes, are common to men, and of a civil kind. Yet among Christians it is mixed with religious engagements, and celebrated religiously in the church. Ministers of the gospel officiate in dispensing the vow, and accompany it with the word and prayer. The parties are bound to marry in the Lord, and to live together as Christians. But is the marriage vow on that account ecclesiastical, Or do the parties engage as church members only? The Christian character is, in such cases, combined with the natural, domestic, civil, political. Much confusion also arises on this subject from not attending to the specific object of our national covenants, and the nature of their stipulations by which they are distinguished from mere church covenants. I shall only add that several objections usually added on this head may be obviated by keeping in mind that the obligation in question is of a moral kind, and that God is the principal party who exacts the fulfillment of the bond.